Hello, everybody, and welcome to History/Law Bite number 290, dated July 22nd, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Brom Bett versus Ashley, aka the Brom Bett case of 1781. Before I go any further, again, I thank you for visiting my channel. And I'll take this time to ask if you would please subscribe to it. Just hit that little red subscribe button, that little bell indicator at the bottom right of this screen. And with it, you will subscribe to my channel and get notices when I post new videos. It's totally free, and I guarantee you, you will not be disappointed with the material. Thanks in advance. So, Brom Bett versus Ashley was a very, very important freedom suit in American history. It was one that took place in 1781 in the Commonwealth of Massachusetts, initiated by none other than Miss Elizabeth Freeman, otherwise known as Brom Bett. Okay? Now, for those who don't know what a freedom suit was, a freedom suit, as it indicates by its simple name, was a lawsuit initiated by an enslaved individual in order to obtain their freedom from an otherwise unrelenting master. Okay? So, this particular freedom suit, Brom Bett versus Ashley, has a lot of significance in American history, all right? And it is a unique one for two primary reasons. First and foremost, it occurred less than 1 year after the adoption of the Massachusetts Constitution of 1780. That's the Constitution they're still using, by the way. And I'd like to add a very important fact about that Constitution. It was written by a founding father, John Adams, our, of course, first vice president and second president, okay? And that is, in all likelihood, the reason that the people of Massachusetts do not wish to do away with this document and replace it with another one. In addition to that, of course, the Constitution also had a lot of foresighted provisions, okay? One of which, declaring at the beginning that all men are born free and equal, is what led to this freedom suit. Okay, so from Massachusetts, okay, where slavery most certainly did exist, contrary to the popular opinion of some, all right, Elizabeth Freeman, all right, was a slave in the household of Colonel John Ashley, okay, and when she initiated this freedom suit, okay, we covered the first reason. This was not, okay, just to obtain her freedom per se, and then to the, rejection of everybody else. It leads to the second reason. The second reason for the significance of this particular freedom suit was that it was a full frontal assault on the institution of slavery in Massachusetts. Okay? So this wasn't just about obtaining the freedom for one or two enslaved individuals. They were going head in to destroy slavery in Massachusetts based upon the language in the Constitution of 1780 that all men were born free and equal. Pretty straightforward, right? So, as a slave in the Ashley household, Brom Bett, served a very prominent family in Massachusetts, okay, very politically active one. Mr. Ashley himself was a judge of the Berkshire Court of Common Pleas, and, in the beginning of 1773, he became the moderator of a group of 11 local citizens, one of which was attorney Theodore Sedgwick, okay? More on him later, though. All right, you'll see his very important role in this lawsuit, okay? This committee would write what would become known as the Sheffield Declaration, all right, in 1773. And that declaration, among other things, expressed the discontentment over Britain's colonial administration of Massachusetts, okay, at this time, and asserted mankind's universal rights to freedom, liberty, and property, all right, and contended that the colonists would use every constitutional measure available to ensure that their grievances were resolved, okay? So this Sheffield Declaration precedes the U.S. Declaration of Independence by 3.5 years, and of course, precedes the Massachusetts Constitution of 1780 by 7 years, okay? Now, to Brom Bett, there is dispute among historians as to precisely what prompted her freedom suit in the first place, okay? And thus it has led to two schools of thought. The first school of thought argues that she was prompted to initiate this suit after she overheard, dinner conversations between Sedgwick and Ashley, discussing the guarantees of freedom in the Sheffield Declaration of 1773, as well as the Declaration of Independence in 1776, and of course the Massachusetts Constitution of 1780. Okay, she was by no means an unintelligent woman, and certainly understood everything they were saying with respect to how all people were entitled to basic freedom. Okay, and that does not take a PhD to understand, folks, and Brom Bett certainly understood that. Okay, now another group argues that she initiated this suit as a result of a physical assault upon her by her mistress, Hannah Ashley. Okay, and what happened was Hannah Ashley was about to strike Bett's younger sister with a red-hot shovel, but Bett intervened immediately, just in time, and saved her sister from the blow. And instead the shovel hit Bett, almost slicing her arm to the bone. The wound did heal, okay? But afterwards she fled, the Ashley residence, okay? And, that was that, per se, with her direct, desire to, not desire, but her direct position in remaining a slave, okay? After that, she had firmly set her mind on no longer being in a position of servitude, okay? Now, whether that particular physical assault prompted her freedom suit, or whether or not the dinner conversations and hearing freedom discussed was the proper motivator will likely forever be debated. But in any case, okay, it was after the physical assault upon her and her fleeing the Ashley household that, she started to turn those wheels toward freedom, okay? So after Bett fled the Ashley residence, Colonel Ashley sought to reclaim his property in Bett, all right? But of course, she was not about to take being returned to a slave without a fight. So she sought the assistance of Theodore Sedgwick. Remember we just talked about him? All right, very prominent attorney, all right, to sue for her freedom, all right? Sedgwick had already developed a wonderful reputation, as a practitioner and as an enemy of slavery, okay? The irony here is that Sedgwick was a close friend of Colonel Ashley, so that had to be a little awkward for him. And I'll add that he was also a regular visitor to the Ashley household, okay? But, right is right and wrong is wrong, friend or not. Mr. Sedgwick was also a prominent member of the committee that drafted the Sheffield Declaration of 1773. So he's not just about the talk, he's also about the walk. So another group of historians also argue that this lawsuit was essentially a test case. That wouldn't exactly be a surprise. That was organized by local citizens in the area, central to western Massachusetts, using Brom Bett and an African-American man named Brom, who was also a slave, to challenge the constitutionality of slavery in the state, given the adoption of the Constitution of 1780, which had language that essentially rendered slavery incompatible with the document. Remember, all men are born free and equal, okay? So the case commenced in May of 1781 when Bett and Brom's attorneys obtained a writ of replevin, okay, which is a common law pleading to recover lost property from the Berkshire Court of Common Pleas, okay? The language of the writ, okay, directed Colonel Ashley to release both Bett and Brom to the custody of the sheriff, all right, as neither one were the legitimate property of the colonel, okay? Needless to say, Ashley refused to comply with the writ's order, and as such, the matter went to trial before the Great Barrington County Court of Common Pleas in August of 1781, all right? So Sedgwick made profound legal arguments, folks, that the continued existence of slavery in the Commonwealth of Massachusetts violated the direct language of the Constitution of 1780. That language read accordingly that all men were born free and equal and had certain natural and inalienable rights, okay? Ashley's attorneys argued to the contrary that the state constitution did not specifically outlaw slavery, okay? And that rights and property were paramount. There they go with that nonsense again. And could be significantly endangered by an adverse decision here, all right? So ultimately, the jury here would rule against Colonel Ashley and in favor of Bett and Brom. They determined that Bett and Brom were not Ashley's property, okay, and discharged them officially from servitude. Each were awarded 30 shillings in damages, all right? Each or collectively, the historical record indicates the jury awarded 30 shillings in damages. Whether that was collectively, which I actually think it was, we'll leave it at that, and they awarded them 30 shillings in damages. And of course, Ashley would appeal this to the Supreme Judicial Court, but he later withdrew this appeal with the Supreme Judicial Court's initial decision in the Quock Walker case, which is another landmark freedom suit, all right, in the Commonwealth of Massachusetts, which had essentially ruled slavery to be incompatible with the state constitution, okay? So after she was officially granted freedom, Brom Bett, a.k.a. Miss Elizabeth Freeman, which is what she became known as after she was officially manumitted from Ashley, she lived for many, many, many years thereafter as a free woman and a faithful household of Attorney Sedgwick, who had essentially won her freedom, okay? She died at the age of 85 in 1829, and because she was such a loved and respected member of the Sedgwick family, she was buried in the Sedgwick family plot in Massachusetts, okay? Sedgwick himself would continue to have a very prominent legal career and served on the Supreme Judicial Court of Massachusetts, which of course is that state's highest court for those who aren't aware, from 1802 to 1813 when he himself passed. Okay? So the legacy of this is quite clear, folks. Brom Bett's case was a profound one in the history of Massachusetts and the United States of America in general. Okay? And this is documented as the first, or certainly one of the first, challenges to the institution of slavery itself via litigation in this country. Okay? And one that would ultimately be victorious. Okay? This case, okay, along with the Quock Walker case covered in another video, okay, would be the death knell for slavery in Massachusetts, folks. And with that, essentially by the mid-1780s, okay, slavery had virtually lost all legal support in the Commonwealth of Massachusetts, okay? And thus, Massachusetts was and will forever hold the claim and title to be the very first American state to do away with the institution of slavery. Okay? And that is something that is evidenced in the fact that in the federal census of 1790, the very first U.S. census ever taken, Massachusetts was the only state to register 0 slaves. No other could do that. So that is Brom and Bett versus Ashley, 1781, a landmark freedom suit in the Commonwealth of Massachusetts. So I thank you so much for listening to this video. If you have any questions or controversies, you can leave them down below and I'll be happy to answer them. If you like this video, you learned a thing or two from it, drop me a like. All likes matter, okay? And if you've not subscribed to my channel at this point, I humbly invite you to do so now. Just hit that little red subscribe button and that little notification bell at the bottom right of the video, and we'll be in business. Again, thank you so much for listening. Your support is appreciated more than you'll ever know, okay? Take care, stay safe out there, and I'll talk to you at the next video. Peace.